Welcome everyone. Continuation today on our discussion of civil liberties. Today we're going to tackle the Second Amendment, which, especially here in the Midwest, this can be a very, very contentious subject on both sides. So, and I will preface it by saying there is no easy answer. I can sit here and I can, claim to say, from a constitutional perspective, this versus this. But in reality, it always comes back to, and as you guys know, as we've discussed before, it will always come back to the Supreme Court and what their decision is on all of these issues, whether it be speech or religion or any of those. And so, with the Second Amendment, I think we start with the text in the Constitution, in the Bill of Rights that was added: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And when I first introduced this in that introductory video, there are basically two parts of this. The first part, is a well-regulated militia, and that is an argument that is made, and I will use right and left, and hopefully I don't offend anybody, but people on the left will say that the Second Amendment is a militia. It doesn't give you the right to own anything you want. The second part of that, however, that we cannot ignore is the right of the people to keep and bear arms shall not be infringed. And so that will be then this argument that's been going on for, especially in the last 20 or 30 years. The argument before with both sides, people of the court, or with the Supreme Court, what is going on here? And so let's go back to the beginning, because if you look at most of the writings from the period, in the 18th century, when they were coming up with the Constitution, when they were talking about this, you had Federalists versus Anti-Federalists. And most Constitution scholars agree that in the beginning, the founders did, add that Second Amendment because of the need for a militia. We didn't have a standing army. We didn't have, this idea of the federal government coming in and taking care of everything and taking care of everybody. So people had to do it themselves. The big issue in that argument, if you go back to the 1770s, 1780s, is what happens if the government becomes corrupt, or what happens if the federal government, cannot take care of us? What can we do? And so they added the Second Amendment. There was a fear that with the war against Britain, fresh in their memories, what happens if the government becomes tyrannical? So the Second Amendment initially was put in there, and most people agree on this, because we needed to form a militia to protect us from a tyrannical government. And that's the way it was. Fast forward then to the 1860s, and you have the Civil War issues. You have the Civil War amendments, 13, 14, and 15, which, obviously the 14th is the one that we talk about the most in this class. But that Second Amendment, in a very well-regulated militia, the right of the people to keep and bear arms, that is still an issue. And what happens after the Civil War is you have these things called the Black Codes, and a lot of white people, legislatures in the states would put in laws preventing the newly freed blacks from owning guns, because they were the fear was that blacks would rise up and try to overtake whites. So they passed these laws called the Black Codes that prevented blacks from owning guns. And lawsuits were put forth, and cases were put forth. And so essentially what happened as a result of the Civil War is the 14th Amendment's privileges and immunities clause. We talk about the due process and equal protection clause in the 14th Amendment, but we don't really talk about the privileges and immunities clause in the 4th Amendment. But essentially what that did, the privileges and immunities clause, gave the newly freed blacks citizenship, and the laws have to apply to everybody equally. So everybody has the same privileges as everybody else. That became the driving force in applying the Second Amendment to people, especially the newly freed blacks, and allowing them to own firearms. So that became then the issue in the 1860s. Now, after that, there was a couple of cases in the 1930s, but for the most part, the Second Amendment wasn't a big deal in the United States as far as when it comes to the court and cases that were brought before the court. So the question really wasn't addressed. When it became a bigger issue in the 2000s, and that's we go back to 2008, kind of the first big case, and this was D.C. District of Columbia versus Heller. And the background here was that in the District of Columbia, being a federal district, laws were passed that prevented people from owning a handgun. So there was this handgun ban on people. And of course, this went through the court system and people sued. And as a result of this case, the Supreme Court overturned those laws, which allowed people saying, hey, the Second Amendment applies to people in the District of Columbia, and you cannot pass these laws outlawing handguns. Now, it was specifically handguns in this case. Now, the key to this case, and I think you guys can see this coming, is the idea that this was the District of Columbia, which is a federal district. So the 14th Amendment basically says no state shall deny. Well, the District of Columbia is not a state. So this case, as important as it was in overturning that law in D.C. versus Heller, it only applied to the federal government. It's going to take another couple of years, and this is the case that we need to have to really pay attention to. This is one of the required cases by College Board, and that is McDonald versus Chicago. And this goes back to the idea of Otis McDonald, who lived in Chicago, lived in a neighborhood, and it started to see an increase in crime, an increase in criminal activity, and his house had been broken into, his house and his garage, like 5 times. And so he wanted to purchase a handgun and to protect himself in his home against this crime. Well, there was a law in place in Chicago that you could not own a handgun. So very similar to the D.C. case, only now this is Chicago. So he sues, goes all the way to the Supreme Court. And the Supreme Court, basically looking at the 14th Amendment's due process clause, no state shall deny any person. So we go back to this incorporation clause that we talked about, this incorporation theory. And in this court case, they looked finally at the due process clause, not the privileges and immunities clause anymore, like they did in the 1860s, but now the due process clause. And they ruled that, looking at, the history of the United States, and what the Supreme Court decided was that arms, or, guns, or whatever it is you want to say, are firmly rooted in America's past. And this is something in American history that becomes very, very important. And what they ruled, and this will ring a bell if you think about the cases that we've talked about, especially the Palco case, the right to bear arms, they decided, is a fundamental right. That is the game changer right here, because if it's not a fundamental right, then the states, you won't be able to apply the 14th Amendment. The court ruled in 2010 that the right to bear arms is a fundamental right, and thus you can own handguns in your home for self-defense. Whole lot this case, encompasses, and a whole lot that this case leaves out. And so, we know because of this case that absolutely the Second Amendment is incorporated. It has been incorporated into the states by the Supreme Court. So the incorporation theory did apply in this case. However, like with speech, with religion, with all of those civil liberties that we have, it is not absolute. And so there are some things that, some cases that are still ongoing. There are still some, some issues and some regulations that they can permit. For example, certain weapons, AR-15s, AK-47s, all those guns. There is a difference here, and I want people to understand, especially people on the left that look at, guns as somehow, evil, or it's a reason for a lot of different things. And I don't want to offend you, but there are responsible people out there, and I may get in trouble for saying this, but there are responsible people out there that we can look at as the reason as to why these things can happen, because it is a part of American history, and the court has ruled that it does apply as far as the 14th Amendment. There's a difference between automatic weapons and semi-automatic weapons. Now, obviously, automatic weapons, we're talking about AKs and ARs. There are semi-automatic ARs and AKs. So this idea of, is it automatic, is it semi-automatic? That's going to have to be a case for the court to bring up. Where you can take them, obviously, you don't want people taking them into necessarily schools or places where large gatherings meet. They can still kind of make laws with that. The high capacity magazines is an issue. Should we allow a clip in a gun to hold 50 rounds or just 7? That's another case that the court would have to look at. Licensing requirements are still a thing. Should we then make the decision to, anybody who wants to own a gun has to license that gun, whether it be a handgun, whether it be a rifle, a shotgun, a semi-automatic weapon? There are still laws in place that require you to get a license. And of course, the arguments on that, on both the left and the right are: is it necessary? Is it a step towards the government knowing who owns guns? That's up to the court to decide. I'm not going to discuss that here. And then whether or not should we allow convicted felons or people that are mentally ill to own guns? All of these things are still regulations that are permitted, even though the Second Amendment has been incorporated into the states. So, final thoughts on this, guys. There are so many more cases that we're going to see, and the court right now has a case pending, a Second Amendment case, but certainly we're going to have many more cases coming in. Whether you are a person who is pro Second Amendment, anti Second Amendment, it doesn't really matter, because bottom line, it always comes back to the court. So my opinion doesn't matter. Your opinion is not going to really matter. In this class, what we do is we take a look at the court and what they're doing. So I'm sure I'll get some comments on this one. Leave comments. You can email me again if you need to email me, ronaldstallard@smsd.org. That is my school email, and I will certainly get back to you as soon as I can. So, Second Amendment, always interesting. All right, until next time. See you guys.